everyone. My name is Siddhi Surpa. This is team Mavericks and we are from Tata Stripe. We are here today to talk to you about Indian labor law, its importance in the society and some important laws which all should know. The word law creates confusion among people. Our objective isn't simple to make this video informative, useful by making it crisp. We want to take this opportunity to thank following us by clicking this video to learn with us. So, we wish you a happy journey.
Hey, Indian labor law. We can say Bharat mein Shram Kanun. So what is it? Let's understand the meaning.
Labor law is a law which regulates the relationships among workers, trade unions, and the government. It is a law relating to rights and responsibilities of the workers. It relates to matters of employment, remuneration, conditions of work, trade unions, and industrial relations. Thus, labor legislation refers to all laws of the government to provide social and economic security to the workers. These acts are aimed to reduction of production losses due to industrial disputes and to ensure timely payment wages and other minimum amenities to workers.
Let us understand the importance of labor laws now.
Maintenance of industrial tranquility, preservation of health, safety, and welfare of labor, maintenance of cordial employee relations, saving labor from profit-seeking exploiters, promote harmony between employer, strengthen industrial relation, provide machinery to solving industrial disputes, protection of women and child in the factories.
So confused? There are so many laws. It's really, you're right, not possible to remember all these laws in one go. But don't worry, chill. Today, we are going to learn some significant ones. So, देर किस बात की? Let's go. आगे बढ़ते हैं.
Hi friends, let's see in this video section of key labor laws and their provisions. These significant laws should be known to everyone. So let's see the list of major labor laws act in India.
Apprentice Act 1961, the Trade Union Act 1926, Factories Act 1948, the Payment of Wages Act 1936, Industrial Disputes Act 1947, Minimum Wages Act 1948, ESI Act 1948, EPFO Act 1952, Maternity Benefits Act 1961, and Sexual Harassment of Women Employees at Workplace Act 2013.
Apprentice Act. Apprentice Act is to provide for the regulation and control of training of apprentices and for the matters concerned therewith. The Act has got importance in view of the thrust of present government on training and employment generation. The slogan of Modi government is Sikho Hunar, Bano Honhar. This intention is to make India the skill capital of the world, make in India. Let us see the objective, applicability, eligibility, time period, health and safety provisions, working hours, leaves, holidays and payments of an apprentice under this Act.
Let's talk about Act number 2.
Trade unions are a very strong medium to save the rights of the employees. These unions have the power to compel higher management to accept their reasonable. Article 19(1)(c) of the Indian Constitution gives everyone the rights to form associations or unions. The Trade Unions Act 1926, amended in 2001, and contains rules on governance and general right of trade unions. ट्रेड यूनियन एक ऐसा संगठन है जो कि किसी व्यापार या कंपनी में कार्य कर रहे श्रमिकों और नियोक्ता के मध्य उसके आपसी संबंधों को सुधारने और संतुलित बनाए रखने का काम करती है। इसी संगठन के माध्यम से श्रमिक नियोक्ताओं से अपनी वैधिक मांगों की पूर्ति के लिए विधिक तरीकों से अनुरोध कर सकता है।
Let's talk about Act number 3.
In India, the first Factories Act was passed in 1881. The main objectives of the Indian Factories Act 1948 are to regulate the working conditions in factories, to regulate health, safety, welfare, and annual leave, and enact special provision in respect of young person, women, and children who work in the factories.
Wages Act 1936. This act ensures that workers must get wages and salaries on time without any unauthorized deductions. Section 6 of the Wages Act 1936 says that workers must be paid in money rather than in kind.
This Act has the provisions regarding the fair dismissal of permanent employees. A worker must be given valid reasons before dismissal. An employee of permanent job nature can only be determined for proven misconduct or for habitual absence from the office.
In this part, we will know about ESI, Employees State Insurance 1948 Act. So let's know more about this. Health insurance first discussed in the year of 1927 by Indian legislature. This is originally called Workmen's State Insurance Bill. In 1946, and it comes into force on 19th April 1948. The objective of the Act is to secure sickness, maternity, and medical benefits to the employees of factories and establishments, and dependent benefits to the dependents of such employees. EPF is the main scheme under the Employees Provident Fund and Miscellaneous Provision Act 1952. The scheme is managed under the Agencies of Employees Provident Fund Organization. It covers every establishment in which 20 or more people are employed, and certain organizations are covered subject to certain conditions and exceptions, even if the employee is less than 20 persons each. The basic objective of this EPFO is to provide monthly compulsory savings for the employees, consisting of matching contribution from both the employees as well as the employer. Mostly, almost any organization in India requires to have registration for PF with basic norms. About contribution by employer and employee. The contribution paid by the employer is 12% of basic wages plus dearness allowances plus returning allowances. An equal contribution is payable by the employee also. In case of establishment where employees are less than 20 or meet certain other conditions as notified by the EPFO, the contribution rate for both employee and the employer is limited to 10%.
Hey, now it's time to talk about rights about women. So let's see.
Maternity Benefits Act 1961
This act entitles maternity leave for pregnant women employees, full payment despite absence from work. As for this act, female workers are entitled to a maximum of 12 weeks or 84 days of maternity leave. All the organized and unorganized offices that have more than 10 employees shall implement this act. Sexual harassment of women employees at workplace. There is an act on this. The act is called Prevention of Sexual Harassment Act or POSE Act. This act prohibits any kind of sexual harassment of the women workers at the workplace. This act came into force from 9 December 2013. This act must be implemented by all public, private, organized or organized sectors that have more than 10 employees. This act covers all women irrespective of her age or employment status. Most Indian employers did not implement this law. So let's see what comes under sexual harassment. Number 1, showing pornography. Number 2, a demand or request of sexual favors. Number 3, sexually colored remarks. Number 4, physically contact or advances. Number 5, any other unwelcome physical, verbal, non-verbal behavior of sexual nature. Number 6, lewd comment.
So these were some important labor laws in India which are made to protect the employment and ensure good working conditions, fixed working hours, fair payment hours and maternity leaves, etc. As we bring our discussion to an end, we are once again thanks to you for allowing us to be here till the end, and hope that this video gives you a much better understanding of Indian labor laws. Thank you so much.